Section 21 of Hindu Adoption and Maintenance Act defines about dependents. So, in Hindu jurisprudence, it lays down a fundamental principles that the property should not be alienated in favor of a stranger in a way that the dependents of the alienator are deprived of their rights to maintenance, and in that connection the very act categorized 9 different classes of persons or dependents, such as the father, the mother, the widow, then the son, son of a predeceased son, and son of a predeceased son of a predeceased son of the deceased, then unmarried daughters, unmarried daughter of a predeceased son, and unmarried daughters of a predeceased son of a predeceased son, then the widow daughter, then widow of the son, and widow of the predeceased son, son of a predeceased son, then the minor illegitimate son, and the unmarried illegitimate daughter. Besides these 9 categories of persons who are found as dependents under the Act, there are certain categories of persons, and they are almost 5 in number, are not entitled to maintenance as per this present act. So, under the present act, the following persons are not entitled to maintenance: disqualified heirs, concubines, the wives of disqualified heirs, sisters, and the fifth one, Ghar Jamai. So, these categories of persons are not entitled to maintenance under the Act. And regarding the very idea of maintenance to the dependents as provided under the Act, we would like to discuss certain important leading case relating to this provision. And out of this, the first one, T.A. Lakshmi Narasamba versus Sundarama. In 1981, the Andhra Pradesh High Court expressed that the maintenance to the daughter-in-law by the father-in-law is a moral obligation by the property left by him either through a will or through gift, casts a legal liability on such person who receives such property. And in the second leading case, Sita Mahalakshmi versus Mandema Pudiyama, in 1984, the same Andhra Pradesh High Court held that heirs of both kind by testament as well as heirs left by the deceased come within the meaning of heirs, and their rights to get maintenance are protected. Here, the very interpretation is a wider connotation, and the last leading case relating to dependents under Section 21 Punalal Hajra versus Full Money Hajra in 1987, the Calcutta High Court expressed that stepson is under an obligation to maintain the stepmother to the extent of property inherited from his father, who was the husband of the stepmother, condition to that the widow had not inherited anything from her deceased husband. And now we'll discuss regarding section 22, which is dealing with maintenance of dependents as per the very provisions of subsection 1, subsection 2, and subsection 3 of section 22. So, dependents to be maintained by heirs of the deceased out of the estate inherited by them, so as it is provided under subsection 1 of section 22. This provision is applicable to those dependents of the deceased before 21st December 1956, and subsection 2 of section 22 provides if the legal heirs do not succeed to the estate of the deceased either through will or excluded are not liable, but those who take the estate, they would be liable to pay maintenance. And subsection 3 of section 22 says that the liability each of the persons inheriting the estate of the deceased would be in proportionate to the share which they get as heirs to provide maintenance, and in connection to that we will discuss regarding the very quantum or amount of maintenance as provided under section 23, and that also under subsection 1, subsection 2, and subsection 3 of section 23. So, regarding amount of maintenance, subsection 1 of section 23 says it shall be the discretion of the court to determine the very amount of maintenance, and subsection 2 provides the following condition to be followed by the court before determining the amount for wife, children, and aged, old, and infirm parents, and they are: the first one, the position and status of the parties, and the second one, the reasonable wants of the claimants, and thirdly, if living separately, whether it is justified of such demand of maintenance, and the fourth one, the value of the claimant's property and any income from such property or claimant's own earnings or from any other sources should be considered while awarding the very amount of maintenance or determining the very amount of maintenance. So also, the number of persons title to maintenance should be decided by the court, and subsection 2 provides determination of the amount of maintenance to a dependent by following the principles underlined here. So the first principle, the net value of the estate of the deceased after payment of debts would be considered. And the second principle, the provisions, if any made under a will, it should be considered. And third principle, the degree of relationship between the deceased and the claimant must be determined. And the fourth one, the reasonable want must be considered by the court. And the fifth one, the very past relation between the claimant and the deceased must be considered. Then the very value of the property and any income derived from such property or from the earnings of such dependent shall be taken into consideration. And lastly, the very number of dependents entitled to get maintenance, it shall be taken into consideration. And in that connection, we'll discuss two leading cases. One is Magan Bhai Chotu Bhai versus Maniban in 1985. The Gujarat High Court expressed that one third or one half, depending upon the conditions and circumstances in which maintenance is claimed, could be announced by the court. And in the another leading case, Rashmi Mehra versus Sunil Mehra in 1991, the Delhi High Court expressed that the quantum of maintenance depends upon the position and status, including financial position of the party. And section 24, 25 and section 26 of the Hindu Adoption and Maintenance Act 1956 provides, as per section 24, the person claiming maintenance must be a Hindu, and section 25 expresses that the amount of maintenance may be altered subsequently if there is a material change in the circumstances. And section 26 regarding debts either contracted or payable by the deceased shall have priority over the claims of his dependents regarding maintenance. So, all the provisions as provided under Hindu Adoption and Maintenance Act 1956 is hereby completed, and in our upcoming video we will discuss regarding Hindu Minority and Guardianship Act 1956.